Hello, YouTube, my old friend. We've come to play the evidentiary game yet again. I'm Vince White. I'm an employment attorney, and we have been talking about evidence. Evidence proving workplace discrimination, workplace sexual harassment cases all week here. And it's given me an idea. It's given me an idea because there's something that I've done in my career for a very long time that has allowed me to help some people that I might not have been able to help and make a significant amount of extra money doing so. What I will do when I'm stumped on a case, when we're really trying to prove something, we're in discovery, and cases are won and lost in discovery. Don't mistake that, right? Discovery is, of course, when you get information from the other side. You get to send them interrogatories, you get written questions, you get to pull documents from them, you get to depose them, all of these things, right? And this is how cases are won and lost. If you are not settling a case and you intend to actually try it, that case is won or lost in discovery. Now, often in discovery, when I'm stumped, when I'm looking at a case and I look at that case and I'm just like, this is not going to be easy to prove, right? And that happens to me less and less in my life these days. I have more control over what cases I take, right? Generally, this firm would not take a case that the partners all didn't want to have, right? But I used to work for other people early in my career, and sometimes those people would just take cases because they wanted money, right? They would just take a big fat retainer up front, or they'd take cases because they were seeing someone, sleeping with someone, or because they wanted to. Right, like there's a lot of really crappy attorneys in the world who will just take cases and then dump them on associates, and those cases are nightmares to litigate. And you sit there looking at a case and you're like, okay, so here's what we say happened, and that, you know, our client's testimony is good, but we need more. We need something to add to that testimony. A case can be won or lost based purely on he said, she said, right? The testimony can be enough. But the attorney's job is fundamentally to reduce risk and add value. And one of the best ways in discovery that you can add value in, especially reduce risk, would be to attach a framework of evidence to your client's testimony. A concept that we introduced in yesterday's video. It's worth checking out. Now, the basic concept here is you have your client's testimony. It's a narrative. I want to attach data points, paper trails, anything, any piece of evidence I can to my client's narrative to make it seem more likely than not that my client's narrative took place as she or he says it did, right? This is providing kind of a extra weight to your client's words, nudging the finder of fact, the jury, the arbitrator, the judge to believe your client, right? That's what you want to do. But those extra data points, that framework, doesn't always come easy. Now, the limitation on obtaining those items in discovery or elsewhere, I often say, is the imagination of the human mind, right? I'll give you a couple examples. Let's say you have a workplace where folks routinely go out to happy hour after work together. And the allegation is that everybody went out, and one of the supervisors from this job site likes to get hammered, and he said some really inappropriate things to one of his direct reports. It's definitely sexual harassment. Maybe he told her she could have a raise, or like maybe she could get in trouble if she didn't do what he wanted. And it was just her and him, and they were, alone at the bar ordering drinks away from the group, so nobody else heard anything. And we brought the case, and now it's he said, she said. Okay. Well, his story is none of that ever happened. He wasn't even there that night. And if he was there, because maybe he made a mistake, maybe he was there, he wasn't drinking much. He buys drinks for the team, not for himself. He's very, very careful. Okay. So let's get into some examples here. He drove to work that day, but I once proved that a fella didn't drive home. He used a rental scooter. We found the rental scooter receipt on his credit card. We knew what time, at least what night it was for. And we said, well, that's weird that you drove your car to work, but you drove a rental scooter from work. You drove your car to work, rental scooter from work. Very strange, very strange. Is that the actions of a sober gentleman? Is that what a sober fellow would do? Or is it something that somebody trying to avoid getting a DWI might do? I think we have a data point, right? Let's keep going. We've, in the past, been able to obtain some Uber cleaning documentation, right? Somebody goes drinking with the team, drinks a little too much, calls an Uber, gets in the Uber, later testifies, no, I was sober that night. I barely had anything. Yeah, okay, you vomited all over your Uber and you paid for cleaning. And it hurt your Uber rating. Not for nothing. We obtained that, right? Like these are the, oh, yeah? Was it just food poisoning? Just magically food poisoning after you had the $400 bar tab? That's convincing. I hope you go with that argument, right? Like, probably not. Probably not. A lot of times, the kind of fella who would go to an office happy hour, get tanked, and then try to use his position to strong arm or scare women into sexual acts and intimacy, they'll often have complaints on dating sites because they're really bad people, right? So, to whatever extent you're able, get that documentation, right? We're still going here. Listen, I worked as a bouncer for a decade, just about. And let me tell you, bouncers, they got nothing to do but sit there and judge you. In fact, it is their job to judge you and how big a problem you're going to be. Bartenders, they don't judge you so much. I mean, they do, but it's not their job. Their job is to get you drinks. But they're a lot closer to you, so they hear a lot of things. And let's face it, a lot of bartenders are often women who get sexually harassed a lot. So they might be very likely to help somebody out in terms of testifying. Yeah, they were at the bar. They were getting kamikazes and Long Island iced teas. And he was saying to her that she had to do what he wanted at the hotel that night, or like maybe she wouldn't get a raise, right? That happens, right? You can go get the bartender, or you can go get the bouncer. Yeah, he kept kind of bumping her, and I stood up a couple of times because I couldn't understand why I was bumping her. It looked like there was, for lack of a better term, a couple of boob grazes, not a grope, but a boob graze, and it made me uncomfortable as a bouncer. And I stood up twice thinking I might intercede, but both times it seemed like she had control of the situation, and then they left. So I didn't actually do anything. I didn't bounce anyone, but I was uncomfortable about the body language of these two human beings, right? Valuable testimony. You can dress that up. How many years have you been doing this? Great. How many fights have you had in your bar? Right. How many of those have you stopped? So like, you're good at this? You're certified? What kind of training? How much experience? You know people for a living. How many times have you been punched in your line of job? Oh, you don't get punched that much because you're good at your job as a bouncer? Great. Amazing. Right? There's a lot you can do with that. Still going. Sometimes people use private investigators. Hit or miss. And it's got more to do with the private investigator than with the vibe. Not all private investigators are created equal, right? But that's something to look at. My personal favorite, if you ever want to prove someone's drinking, we'll just use me as an example, right? If somebody's like, yeah, Vince was drinking that night, and if my testimony is, I definitely was not drinking, just go look for credit card transactions in which I purchased Gatorade and baklava. Would a sober person purchase Gatorade and baklava? You know who would? Drunk Vince. About 100% of the time. Unwise. It's an unwise decision, but it's a really good way to prove that I had a couple drinks that night. Right? And so that's something to look for as well. Now, I threw out all these examples. I made this almost 10-minute video, not because I'm telling you that we're geniuses, because I want to tell you how we arrived at some of these ideas. Staying with the theme, bar tabs. Often what I would do in my career is I would look at a case and I would do a little write-up, completely stripping out any identifying characteristic from my case, right? I don't want anyone else knowing any of the parties. I don't want them, anyone outside my firm knowing what I'm dealing with here, but like fleshing out the scenario like we just did earlier in this video. Company goes to happy hour like every week. This guy we think drinks a lot. Our client says drinks a lot at the happy hour, gets real forceful with her, threatens her job if she doesn't go to the hotel with him. That's our client's narrative. How do we prove that, right? And the answer is you think of everything you can think of, and then you create this complete hypothetical for your employment attorney friends, and you go and invite them to a bar, and you throw your card down on the bar and say, bartender, I would love it if we get a quiet table in the corner and everything these people want for the next 2 hours. And I really appreciate you, bartender, so much. We guarantee we'll tip 30% because we know that attorneys are garbage humans. But you know me, I'm good for it. Cool. And then those people enjoy your bar tab. And because they're ego-driven human beings, that's why they became plaintiff side employment attorneys, they will try to astound everyone with the depths of their genius as to how they would go about proving your scenario. Many of these ideas were not my ideas. Many of these ideas came as a direct result of me paying for Irish car bombs. Now, drinking's bad, and kids, you shouldn't drink. But if you're running a hypothetical and you're trying to think of how to prove something, and you've got 5, 6, 8 employment attorneys sitting at a table trying to outdo each other, that brain trust is, for about the first hour and a half, invaluable. But you make sure you keep taking notes for the last half hour, because people start to say dumb things. And sometimes dumb things, when you think about them 3 days later, can result in a 7-figure verdict for your client. So don't count them out in the last half hour, right? And I guess what I'm saying here is I would love to run, I think there'd be value in me running a couple of hypotheticals provided by you, the people of the internet, by the brain trust, and getting them to wax poetic about all of their great ideas. Now, I can jot down those ideas, but there is zero chance of any of these people allowing me to put a camera in their face. The entirety of the world of employment law thinks I'm a garbage human for doing this YouTube channel, and that's not true. There's definitely people who are cool with it. It just seems like there's more who are not. So there's no chance of me putting, I'm not going to be able to film this brain trust, right? But I am going to be able to take notes. And I think I could present those notes kind of convincingly here. And listen, this is not because I'm such a genius. Firms do this generally within their walls of their own firm, right? I just didn't have as many peers early in my career that I could really work with that well or trust or thought were amazing. So I had to do it external in my firm. I would gather, attorneys from the firm I worked at, but also attorneys from other firms that I thought might have better ideas or might be more open to a give and take of ideas, right? And it wasn't just my cases, we talked about their cases too. I think this could have real value for people. I don't know. I could be wrong. I'm often wrong. I'm wrong routinely. However, I don't think there's anything wrong with trying this. Worst case scenario, I throw away a couple $100 in a bar tab for some people, and the results are junk. We tried, right? Best case scenario, we really help some folks and create some fantastic content. That sounds fantastic to me. I love that idea. I think we should do it. I think we should make it a recurring episode. We'll do it maybe once a month, something like that. Gotta watch. Can't be eating too much baklava. So what I'm saying is, if you want to throw in a hypothetical, be very careful to keep all identifying characteristics completely scrubbed from it. Please do not use your real name. And I will grab a couple of those hypotheticals and I will present them to the brain trust. And I will scribble furiously on my pad, taking notes. And if anyone lets me, I'll put a camera in their face, but I feel like they're just going to slap it out of my hand. We'll do our best, and we'll get you a presentation of some ideas that may or may not have value, right? I don't know what's going to help you prove your case. I do know what I think might help prove your case, and me presenting you that might have some value. Now, when you do this, do not undermine your attorney. If you have an attorney, do not be like, oh, I got these other 10 attorneys to give you an idea how to prove this case. That could damage, like, know your relationship with your attorney and what it is and how it's working and all those things. And present things like tactfully, right? Remember, employment attorneys, we're all off, especially the plaintiff side ones. We're all a little bit off. I mean, if you think about it, like the people who chose to litigate hate crimes and sexual harassment, sexual assault all day, that's not fun for most people. That's a tough job, right? So just be tactful in how you bring our ideas to your attorney if you have an attorney. I hate to see you damage your relationship with your attorney, especially if you're in discovery. That can be a trying time for that relationship. So just be cool in how you bring those ideas to an attorney. But get shooting those hypotheticals over, post them publicly in the comments. I will gather them and I will try to present them at a brain trust meeting and come back with some stuff for you. Like, subscribe, comment down below. Helps me to help more people just like you.